Picking back up H66, we have Damien here to take us through a series of technical and fiscal changes, essentially. So if you want to just, yeah, head our way.
All right. All right, for the record, Damien Leonard from the Office of Legislative Counsel. Coming up on the screen here is a strike all amendment numbered as draft 1.2. The reason you haven't seen draft 1.1 is because it didn't have the numbers from joint fiscal in it. So this is just internal numbering. So the first thing.
Actually, sorry, before you start, I should have said this at the beginning. So want to go through the whole draft, make sure everyone understands it. If you have like a technical noticing or something like that, please let's have that in now, or any questions about understanding, let's do that now. And then after we're through the whole bill, we can have a discussion about specific sections that people have policy substantive questions, suggestions about. Back to you, Damien.
Thank you.
Yes.
I feel like I'm at the desk in a news studio here.
Really trying to channel my anchor spirit. Yeah.
That's right. So the first thing you'll see, I've started adding language to kind of guide people to what we're doing in the bill. So leave from employment is job protected leave, as opposed to leave benefits later, which are the actual insurance. The next thing you'll see is we've added a definition for bereavement leave to our job protected leave law. So one of the things this is trying to do is we had job protection for bereavement leave sitting in the insurance law. So this adds that job protection for 2 weeks of bereavement leave to the job protected leave law, just to avoid confusion about what rights people do and don't have. The next thing we do is we spell out the definition of domestic partner at the bottom of page 1 and onto page 2. This matches up exactly to the definition for campaign finance purposes, except we use the term individual instead and employee instead of candidate. Renumbering throughout here, you'll see we've added to the definition of employer on line 14, we've added and made an employer a person who, for purposes of the parental leave, safe leave, and leave for a qualifying exigency, employs 10 or more individuals who are employed for an average of 30 hours per week. It occurs to me now that we should say bereavement leave somewhere in there. So I'm just going to make a note on my draft here. The other thing, actually that comes up later, so just forget I said that. And so the chair asked me to draft this as 10 or more individuals. Obviously, that's a policy decision. You could put it under the family leave threshold of 15 or more. The next is the definition of employee, which for purposes of safe leave only means a person. So for every other leave, you have to be employed for a year and work an average of 30 hours a week. For safe leave only, you have to have been continuously employed for 6 months and work an average of 20 hours a week. So safe leave is the only one that gets a lower threshold for employees. And that tracks with the separate safe leave law that House General had in their version of the bill. So this consolidates safe leave and bereavement leave into the standard family and medical job protected leave law. Okay. The next changes are all just numbering. I'm going to move quickly here because we have a lot to get through. That gets us down to qualifying exigency, which we've previously, this is a substantive change. Previously, You would only be entitled to job protection for a qualifying exigency if you have a family member who's on active duty military service or called to active duty. If you work for an employer who's covered by FMLA, that's a very small number of employers in Vermont because you have to have 50 or more employees to be covered. This would extend it to employers, I believe, with 10 or more, based on the language above. The next change is adding the definition of safe leave. This definition is identical to the one in the bill that passed out of House General in their separate safe leave section with one change. And that is that we've added a new number 6 on page 7 to attend a hearing concerning an order against stalking or sexual assault pursuant to 12 VSA 5133 when the employee is the plaintiff. This language is from the existing alleged crime victims leave law. So we've moved it from that law to this because it lines up more closely with the safe leave. So the idea was that you group it under the same 12 weeks of leave as you have for safe leave, rather than putting it under a different law. And this will mean that when the paid leave program goes online, you can use paid leave benefits for those hearings specifically.
And the intent for sort of most of these tweaks was less of sort of a policy decision and more like creating sort of a consistency of spirit between the 3 sections. Yeah.
There's no problem using the word plaintiff as opposed to complainant. I target that because in the next paragraph, you use perpetrator, which is not the judicial term, but rather the sort of investigatory term. And
So we're using the term plaintiff in that paragraph because we're specifically talking to a hearing where there's a plaintiff and a defendant.
Okay.
We're using the word perpetrator in C because numbers 1 through 6 in B refer to both judicial proceedings and non-judicial situations.
Fair enough. Thanks.
Yep. These are the good questions though, because this prevents us from having an issue in 2 years where someone says,
I'm not a plaintiff.
right.
Yeah.
Or, you used the wrong word and now you've cut me out. So.
Representative Woody?
I didn't want to get to the policy piece of this, but it's a little plaintiff defendant. If the defendant has a claim that they're being harassed by doing a service, I could see a plaintiff abusing the statute to keep the defendant out of work and not being able to take leave from work. And then the defendant would not become the plaintiff, but the defendant would put in their own, claim that this is an abuse of litigation or whatever. So what do you do about that? You're not taking that into account here.
No, and this is a policy question.
I thought it was.
So there was a bill introduced on that last year by Senator Benning, which would have allowed anyone who has an obligation to appear in court because they're a party in a proceeding to be protected from losing their job. But it's a bigger policy question than what this was addressing, which was to move existing law over from one section to a different section. But yeah, that's something we could address. And if you wanted to introduce an amendment on that, I already have the language. So.
But I would say it is an amendment outside of our committee's jurisdiction and something maybe that, or the House General who does labor law would pick up. Yeah.
Yeah.
And then the other thing is, you don't, now I'm thinking about the courts, but what about leaving for jury duty? You wouldn't want that.
Yep. So again, that's a separate policy question. And this doesn't protect you on jury duty leave. I think our town meeting leave law also includes a provision for jury duty, but I'd have to check. I can get back to you after after today. But that was also something that Senator Benning's bill last year brought up, that idea of being obligated to show up in court for one reason or another versus the current statutes, which are focused on the alleged victim. So, okay. Serious, okay, so we're just renumbering on serious health condition, renumbering with sexual assault and stalking. We've added the definition of U.S. Armed Forces because of the qualifying exigency language.
Then you got the 12 to 14?
Yes.
Okay.
And I'm sorry, there's just one note. Representative Taylor found that I had missed a cross-reference in here. So I appreciate that. I've already corrected it in the next version of the draft. And it's good to have it. Otherwise, I have to do it in technical corrections later or when we're doing the statute. So this saves me time later.
Well, is that something the editors pick up?
They try, but keep in mind, they're reading hundreds of pages a day. And at a certain point, some of this stuff just blurs, the same as it does for the attorneys drafting it. So having fresh eyes on this has been edited and they didn't see it going
Oh, okay,
through.
that's what I
So
was wondering, because sometimes the reply is, well, we'll let editors take care of that.
yeah, in this case, this has been edited.
Okay.
So anytime you can pick it up, it's one less thing they have to notice, which is good. So never be afraid to say, Damien, you messed up. It's very okay with me. So that just added in the definition there. Going on to section 2, this is the existing family and medical leave law. The main change here is we've added or a qualifying exigency. We've then added the 2 out of 12 weeks for bereavement leave. And then we've added the addition of safe leave. The substantive change here between House General and this bill, there are two things. One, we're clarifying that job protection is identical for these leaves as to what's in the current leave law by grouping them all together. The other thing is this is putting these types of leave in there for starting July 1, 2023 on the same basis as parental leave. And then they'll be in the law and just changing the definition of employer in 2026 when the paid leave program starts to line up with the paid leave program. So just something to keep in mind there is this would start those leaves as a job protected leave this coming July.
Question?
Yep.
Do those two paragraphs, 2 and 3, contradict A1?
Nope. So 2 is out of the 12 weeks of leave available pursuant to subdivision 1. You can use up to 2. And then 3 is in addition to the leave provided in paragraphs 1 and 2, you have an additional 12 weeks for safe leave.
Okay, so it's all within 12 weeks.
It's all within a 12-month period. You have 12 weeks that you can use for parental, family, qualifying exigency, and bereavement. You have an additional 12 weeks if you need it for safe, which is consistent with the House General construct. All right.
Okay, I see.
The next change is on page 9. Because we've added bereavement leave and qualifying exigency, we've added those here. So we've added the death of a family member because presumably you won't have notice of that, but you would have notice of, for example, needing to take time off to settle the estate. And then the short notice qualifying exigency, this is when you're called up in response to an emergency versus when you get your orders months in advance. And this is consistent with the federal law. So they describe it, they use the term short notice qualifying exigency. So we're just going with that. Questions? Okay. Next on page 10, we've just switched the word support services to protected tenants, which is from our fair housing program for victims of domestic and sexual violence, to support services to victims of domestic violence, sexual violence, or stalking, to be consistent with the rest of the statute. This was highlighted by, I believe, the network as a potential shortcoming. And this is the certification piece for victims of domestic or sexual violence. The next, we've added in documentation for bereavement leave. This was not in the House General's bill, so this clarifies what documentation you can provide. What I did is I went to other states that have protected leave for bereavement, and I used what I thought was the broadest notice provision, with the idea that if you think anything's too broad, you can trim it down. But it's death certificate, published obituary, written notice or verification of death, burial, or memorial from a mortuary, funeral home, burial society, crematorium, religious organization, or governmental agency. So that covers everything from clergy providing written verification that there was a death to a death certificate from the state. So
I think currently a lot of people's, notice of their funeral, for example, may or may not end up in a newspaper, but may very well end up online by the funeral home or other. Would the law consider that an option?
that would be, I think, would fall under written notice of death or memorial service from a funeral home.
Okay.
And then also published obituary would cover like an obituary in Vermont Digger, the same as it would in the Times Argus. So. Okay. The need for qualifying exigency, we've just made that consistent with the federal law. So we're continuing to follow federal law on the requirements for that. And those are the changes from House General in the underlying job protected family and medical leave law, which would now be family and medical and the other types of leave. The Section 3 is brand new, and the only change here is we've struck out the language regarding hearings related to for an order against stalking or sexual abuse, or sexual assault, because we've moved that over to the other job protected leave law. So this isn't actually a really substantive change in the law so much as a technical change just to move the language. Questions? Okay.
Yes.
Oh, maybe it's policy. Never mind.
Okay.
Okay.
Yes.
So just to clarify, so you can have up to 12 weeks of paid leave and then an additional 12 weeks unpaid leave to deal with stalking or other abuse issues, safe leave.
Yeah, so the way it works is the job protected leave is technically it's unpaid leave.
Right.
You're entitled as an employee, if you have it available, to use accrued paid leave benefit or accrued paid leave time, or any insurance that you have that would cover and provide wage replacement. And then when the paid family and medical leave program comes online, you're allowed to use those benefits too. There is no cap on how many weeks you can use combined, but you're limited to 12 weeks under the program. And then after that, you would have to use accrued paid leave. So if you took your maximum of 12 weeks of parental and family leave, and then you had a safe leave need, you would have to use whatever paid leave you have available or take it unpaid.
Right.
So
But you could take an additional up to 12 weeks of that
up
job.
to 12 weeks in a 12-month period.
That's what I really wanted to be sure of.
Yeah. All right. So That all happened, sections 1 through 3 all happened July 1 of this year. Sections 4 and 5 happen January 1 of 2026 in this bill. So they coincide, or in this draft, they coincide with the proposed start date for the program. And so that date would change if you change the start date to the program from what's currently proposed. The first thing is a numbering change in here. And that's just a change from House General's bill because we renumbered in the first one. So this was more for my editors than for anything you need to worry about, just so that they could see I was updating the numbers throughout. The next piece here is what's happening in the bill is we are, because of some issues that we noticed with the underlying federal definition of wages for purposes of a W-2 versus a 1099, the bill has changed its definition of wages, or this proposed draft changes its definition of wages because the Internal Revenue Code definition excludes wages paid to domestic workers, agricultural workers, and others. And this bill, as I mentioned in my earlier walkthrough, was intended to cover them. And I was not aware of that issue until it was brought to my attention. And so the chair asked me to put in a new definition of wages that would fill those gaps. So what we've now said here is required to withhold family and medical leave insurance program contributions, which is consistent with the underlying intent, which was just that if you're doing this wage withholding.
Representative Anson?
None of this interferes with the nuance of payment, which is wages in the case of family leave, but not wages in the case of injury to the applicant themselves.
You mean in terms of like workers' comp?
Yeah.
Yeah, so this, one thing to keep in mind, and this is a very confusing thing in employment law, is you can be an employee for purposes of one law, but not 6 other laws. And that's what's happening here.
Okay,
So you're made an employee for purposes of job protected leave.
right.
You are not an employee for purposes of unemployment insurance or workers' comp because of this change.
Yeah, we are not wading into any of that territory.
Yeah, this,
Under any circumstances.
The only reason I say
You know,
that,
it's a good question.
one of the folks who were in, I don't know if it was you, who said, by the way, if you're taking medical leave for a covered on-the-job injury, it's not wages, whatever money you receive.
Oh,
And that,
so-
I just wanted to be sure that this language doesn't undo.
no, this isn't
That
gonna
distinction.
undo that.
Okay.
So that's how the Internal Revenue Code views the income you receive from the program.
Correct.
Whether it's in the nature of workers' comp or disability compensation or unemployment compensation. And this doesn't undo that.
Okay.
So,
This is seasonal employees.
yeah, so this would cover seasonal employees. You'll notice that it does use the present tense is employed by an employer because this is the job protected leave law. So you don't have a job to protect if you're not employed. But as long as you've been employed in 2 of the last 4 calendar quarters, and your employer's been making contributions, you're covered. Right. The other thing we've added here, this was a gap I noticed, is that we hadn't covered private plan employees because they're not paying contributions. And now that we've shifted it over from your payroll, your wage income tax withholding to contributions to the program, we have to say that you've worked for an employer during 2 of the last 4 calendar quarters, or the employer, and the employer is required to provide you with coverage under a private plan approved pursuant to the new program. So this just covers those employees too, so they're not being treated differently.
And again, this is essentially a technical fix because we were cross-referencing something that had sort of more depth than we previously realized.
Exactly.
Just clarifying something with the two of the last 4 calendar quarters. So it doesn't have to be a full quarter. It could be that they worked for the last week of June and the first 2 weeks of July,
Yep,
harvesting a strawberry crop,
that's right.
and then they're covered.
As long as,
As
so
long
this
as
is the job protected leave here?
Yes.
So as long as they're still employed, but say they were brought on by a farm to harvest the strawberry crop, and they then have the need for the leave in mid-June or mid-July, when they've now moved on to working on the tomato crop, they would be covered for job protection, assuming that their job will still exist when they would return from the leave.
Okay, thank
So
you.
that's the one thing with seasonal employees that you'll run into, is if your job would have ended for a reason that's not tied to the leave, ski resort closed, the farm is finished harvesting, when you get back, you're not entitled to the job, so.
And this isn't usurping that.
No, this isn't usurping that, this is continuing that, and this is just a good example here of when you pull one string out and you have to knot together 2 or 3 other strings that have come loose. And so that's what we're doing, just to keep it consistent. The next is, I was just showing editing here that this was new language from the previous draft. It's not a change from anything you've seen. So this was added in section 1. And again, with the U.S. Armed Forces, that was added in section 1. Section 5, again, this is a January 1, 2026 amendment to the underlying leave law. What this is reflecting here, again, is this is the same as the underlying bill with the changes highlighted that you saw in section 1. This was just for my editor's purposes here. And that gets us to the end of the first 5 sections.
Congratulations.
Record time, only 37 minutes.
Do you have a timer going on your computer?
I have a clock. I don't know when we started. It's just 37 minutes since I was supposed to start.
Sounds good.
Yeah. All right, so this is getting us into the insurance program. So just renumbered the section here to start off with. I'm gonna skip ahead. So this is special fund language revisions recommended by Emily Byrne from JFO. After she looked at the language, she found a few issues here. So the first is we're saying it shall be administered by, and then we're referencing the Division of Family and Medical Leave and the Department of Taxes rather than the director and the commissioner. Traditionally, we've referred to the head of the agency. She raised the point that someone could argue if the position of head of the agency is not filled, then potentially you shouldn't be accessing the funds. So this is a clarification. Monies in the fund may be expended for the administration, payment of benefits, and necessary costs. That's all existing language, just broken into a new sentence. The next piece here, we've updated this language because I said any amounts appropriated to the fund. She pointed out that more often than not, we transfer to the fund rather than appropriate, although we do still use the appropriated language. So this is more accurate. And then the rest is existing language, just moved to a new subdivision. And that brings us to the contribution rates. This is revised because if you'll remember when I came up here with the draft from House General, it said the rate is 0.55%, but then annually we're going to adjust it, which is confusing. So subsection A now says contributions for employees and enrolled self-employed individuals shall be apportioned as followed. An employer may deduct and withhold from an employee's covered wages up to 1/2 and shall remit the full amount to the Department of Taxes. it occurs to me that you may want to flip the unhighlighted portion with the highlighted portion, so it's more clear right off the bat that employers are responsible for paying the full amount and then may withhold up to 1/2 from the employee's wages.
Representative Sims?
Is it weird to have A reference self-employed individuals and then 1A is referencing employers?
Well, 1B or 2A2 references self-employed. So they're both in there. We could make it A for employees and B for self-employed.
Are you saying that when we scroll down, it'll be clearer?
Yeah.
Well, or
But if,
I think it's weird to have a header that refers to something in a bullet.
yeah, so when you get down to line 15,
I see that down.
yeah,
Maybe
but
separate.
if you'd prefer to separate them, we can do that. I'm seeing.
If you want to flip those sentences, feel free.
Okay.
Representative Anthony?
I would agree about flipping, because in the sales and use language, it's, you're the trustee. And that's the sort of preamble to the paragraph about who's responsible for what.
Okay, I will break those out into separate subsections, flip the sentence.
Remember, you're the one who wanted to flip the sentence.
I'm just reading it and,
I think you're right. Absolutely, yes.
so whatever it can do to make this more clear, is something that I would suggest. And if I'm not making it more clear, just tell me. Okay. So anyway, contributions. So an employer is responsible for the full amount, for remitting the full amount of the contribution, but they can deduct and withhold up to 1/2 of it from the employee.
Yep, go ahead.
That's just allowing that they can make a larger contribution if they would like to do that. Is that correct? Or, well, protects the employee, but also
Yes.
allows them to do that.
Right, it allows the employer to determine if they're gonna deduct and withhold anything. So they could cover the full amount, which for some employees is only about $60 a year. For other employees, it could be substantial.
And the way I think about this, and please correct me if I'm wrong, is that it sort of the way it's written now, it functions like a trust tax, though it is not technically a trust tax, and that sort of the responsibility for the remittance sits with the employer.
Yes.
Okay.
Yeah, and that's the design. It's just like FICA. Responsibility for getting it to the federal government sits with the employer. The employer deducts 1/2 from the employee, but if the employer doesn't pay the full amount, the responsibility is with the employer. So the IRS goes after the employer, not the employee. That's the idea here. Covered work income, same definition as before, except we've added the word, I'm skipping ahead. Covered wages, same definition as before. All wages paid to an employee up to 2 times the Social Security contribution and benefit base. The one thing we took out is the maximum Social Security contribution and benefit base, because it's just the Social Security contribution and benefit base. Why is that a mouthful? In 2, which will become B, enrolled self-employed individuals pay the full rate of contribution required pursuant to what will now be subsection C. On the enrolled self-employed individuals covered work income. With covered work income, we clarified that it's gross self-employment income. And it's up to 2 times the Social Security contribution and benefit base. Questions?
The purpose of the covered wages piece is to cap the amount that someone has to pay into the program, is that correct?
That's correct. So.
Yeah, sorry.
Kind of going to the self-employment piece. I'm not clear that this represents that it's gonna be estimated
It is,
earnings. Is that, I'm sorry if that's a confusing way to put it.
so it is not necessarily estimated earnings. As a self-employed individual enrolls, you have to document your income for the program because they have to know what you've been making to provide you with benefits. So,
I see what you're saying, okay.
yeah,
Is there language later that describes that documentation?
yes. That's in the self-employed individual. It says you shall provide documentation of income as required by the director. So,
So would that be as part of providing your tax return each year, or would it have to be
I think it's,
communicating directly with the treasurer's office?
I wonder if we could wait until we get to that section,
Okay, yeah.
because that's right, we're not there yet.
yeah,
Okay,
and it's, yeah, well, we
Sorry
can
to-
address it then, that's
Very
fine.
linear, I'm sorry.
Yeah.
Can we get the bill in table format next time?
Haven't really
I don't think we have enough wall space. Yeah,
Representative Meadows.
So why is that not net self-employment income?
so I was asked to make it,
Would you rather I answer?
so I would defer to the chair and Representative Sims, who made the request that it be gross instead of net. So,
Your gross, basically, when you, the thinking was that as a person paid wages, the amount of money that you experience into your bank account is your net income. But as a person who is self-employed, the amount that you experience coming into your bank account on a regular basis is actually your gross income. And then you pay taxes on that later, rather than paying taxes on it as you go. And so the insurance payment, family leave money coming in as, like, you want to document as gross and having it come in as gross because you're going to be paying taxes on it after.
So if I do a job for $10,000.
Yeah.
It cost me $6 to do it. I netted $4. That's really the money I have in my bank account. But you're gonna tax me on the total. Even though I didn't make net out 10,000.
Oh, because you're thinking of and I think I was thinking net and gross in terms of pre-tax and post-tax, and you're thinking of net and gross in terms of expenses.
Cause I'm reading.
Yes, no, that's a really good point, yeah. And I think you were also thinking of it in terms of pre-tax and post-tax.
Yeah, I mean, I do think of it also in terms of impact on wage replacement if you took advantage of the insurance program, especially as a self-employed person. Some of your expenses might continue regardless of whether you were able to. So like, if you have experienced the birth of a child, you might continue to have to pay your ongoing expenses for your rent and your truck, and you might be better supported by a benefit that looked at your gross income.
But that's not an accurate picture of what you earn.
I think of gross as the same thing. That's how I think of gross.
Said it right.
Which is,
I agree with
in a
Yeah.
heavy overhead, self-employed, that's gonna drastically change.
Yeah, that's a really good, so let's flag that as something to come back to. It's a really good point from a policy perspective, and I think we were all having different understandings of what that language meant.
okay. So in B1, for the period from July 1, 2025 to December 31, 2025, the contribution rate for employees and enrolled self-employed individuals shall be 0.55% of covered wages or covered work income, respectively. So very important to note here, this is the contribution rate, and this is part of why I wanted to flip that sentence. Contribution rate that the employer or the self-employed individual is required to remit is 0.55%. Employers can withhold up to half of that from the employees, but they're not required to. Does that make
Can
sense?
you, yeah, except when you started that paragraph, you said employer rather than employee.
Yeah, so that's a confusing thing, but it's the rate for each employee is 0.55% of their wages. Employers pay the rate for each employee, and then in the aggregate, pay for all of their employees. So so we're really talking about, you have two types of covered people, employees and self-employed individuals. But in A, we're saying employers are responsible for remitting that full 0.55% and can withhold up to half of the rate.
Which
from
is
their
that little
employees.
a or big A or which?
That's little a. So if you go back to the previous page, when we flip the sentence, it will say an employer shall be responsible for remitting the full amount of the contribution required for each employee to the Department of Taxes. However, an employer may deduct and withhold from each employee's covered wages an amount equal to 1/2 of the rate of contribution required for that employee pursuant to. Does that make sense?
Yes, and then B comes in
Yep.
and says 55%, 0.55% comes from the employee.
No, I will try to write this more clearly because it is, the idea is that this is the contribution rate paid on employees' wages. So I'll write it as contribution rate due on wages paid to employees. Would that be more clear? Because and I can even say contribution due from employers on wages paid to employees shall be 0.55%.
That sounds more.
Does that work?
Yep.
Okay.
I just don't want it to look like the employee's paying 0.55% during that time period.
Okay. I will clarify that. Then beginning calendar year 2026 and annually thereafter, the director shall establish a rate of contribution on or before the preceding October 1. This is very similar to how we set the minimum wage and update our unemployment compensation rates and so forth. Director sets it so that it generates the projected amount of benefits, projected administrative costs, and then plus a reserve equal to 6 months of the projected benefit payments and administrative costs for the next calendar year. That is a substantive change. So the underlying bill from general said just the projected benefits. This is a benefits and administration. If you remember when we talked about the breakdown on reserves, some states say benefits, some say benefits and administrative costs. So when you're saying 6 months of benefits and administrative costs, it's like you're adding 10% to that number, minus any balance. So, and then the rest of this is.
And just like full transparency, this is changing the reserve from what came over from
Yes.
us general based on some research that Damien did that we were like, our reserve is way higher than any other state.
Yeah, there's only DC has a 9-month reserve. Everyone else has 6 months or less. And in some states, apparently none.
Yeah, really.
So the rest is just renumbering here. Whoop, that's a big change. Benefit rate dropped from 100% to 90% of the individual's average weekly earnings. This will ensure that individuals are not taking home more money than they would have while being employed. So that brings us to eligibility. This section changed in a number of different ways, which is why I've highlighted the whole thing. So we've clarified that the individual is currently an employee or an enrolled self-employed individual. We're gonna look at that definition of employee later because it doesn't mean currently employed, which is confusing, I acknowledge. The next is except as otherwise provided pursuant to subsection 2059F, which we'll get to in a minute. And that is for individuals who are coming off of a private plan that's been terminated for one reason or another. They have a separate set of requirements here because this relates to the wages from which contributions were withheld or making contributions to the fund. If you're coming off of a private plan, you won't have done either, but we have some protections that are added to protect those individuals if their employer goes out of business or something like that. And then we've added or both, which I think was in the underlying draft. It just means you can be either an employee, self-employed, or both. And the same thing here, earned wages from which contributions were withheld. So there are two options. The first is during 2 calendar quarters in the preceding calendar year, or paid contributions on covered work income during 2 calendar quarters in the preceding calendar year, or both. The reason we have preceding calendar year is because with that, we have your tax returns. There's no need to provide additional documentation to verify your income. So you've got your tax returns that show that income. With B, we're looking at if you were not employed in Vermont in the previous year or not for long enough to qualify, this is your backup qualification. You've earned wages in 2 of the last 4 calendar quarters and provided documentation of those wages that's acceptable to the director. This could be pay stubs, a pay statement from your employer, or something else. Or you've made self-employed contributions and provided the documentation of that covered work income that's acceptable to the director. This gets to the issue that you may provide quarterly statements to the director, but as a self-employed person, you may not have a complete statement when you file that because of the way revenues are coming in. And so you'll resolve that at the end of the year. But the director can require documentation. And then if you provided acceptable documentation, you're qualified for the benefits. So it's just encouraging people to provide that documentation as they go. Or both again. So I did have a question about why I spell out or both. The reason is because there have been arguments in recent years that when we don't do it, we mean that you can't do both. And so we've had to get extra redundant with our language, which I appreciate your tolerance for that. So the individual is unable to work. Again, this is the same as the underlying bill, except that I believe I had inadvertently left out qualifying exigency or safe leave. I can't remember which. Either way, I've made sure the list is complete in here. So that was a mistake in the underlying bill. And then the director determines that the individual is not disqualified. That's the same as the underlying bill. Questions on that section? So there were a lot of little changes there. The biggest one being how you qualify as being an employee who's been in the program for long enough. Okay, no changes to the application for benefits. I should also ask, we're at 11. Do you want to take a break, Madam Chair, or do you want to keep pushing?
Do you want to take a break?
I would love a break. So.
We're going to take a break. We'll be back here at 11.